Recently, the government arranged some wholesale changes to the way that the courts are going to deal with whiplash claims. If you hurt yourself in a road traffic accident or perhaps slipping on something in a supermarket, the courts used to have a scale of compensation that would typically be awarded depending on the length and the degree of severity of the whiplash injury you suffered. And whiplash injuries aren't just to the neck necessarily. You can have similar sorts of injuries called soft tissue injuries to the back as well. They can be quite debilitating in terms of pain. They can last a very long time. They're very difficult to prove or disprove with medical evidence, and GPs and medical experts tend to be reliant on the symptoms described by the individual who suffered from the accident. But changes are being announced due to pressure from the insurance sector. To help understand those changes, I'm joined by James Counsell QC, a barrister from Outer Temple Chambers. Full disclosure, Outer Temple also happens to be my chambers. James, good evening.
Hey, Daniel.
Can you explain what the changes are?
Yeah, I can do. Right, first of all, how does it work? Well, first of all, it applies to all claims where the accident which causes the whiplash injury occurred on or after the 31st of May of this year, so a couple of months' time. So if you've already suffered an injury or you do so before that date, you're not covered by the scheme. Essentially, the scheme applies a tariff which the court must apply depending on the duration of the injury and its severity, in brackets, from a whiplash injury which lasts up to 3 months to one which lasts no more than 2 years. Anything over that period of time is not covered by the scheme, but that, of course, will cover most whiplash injuries. How much will a sufferer get under the scheme? Well, up to 3 months, someone will get £240. 18 months to 24 months, the figure is 4,215. And that figure can be increased on two grounds. First of all, if there's an element of psychological injury, it's increased by a little. And if the injury is what's described as exceptionally severe, whatever that may mean, there can be up to a 20% uplift can apply to that figure.
Another change is that any claims worth in total less than £5,000 will now go into the small claims track. What does that mean?
Yeah, well, the small claims track is there are three different tracks for which you can make an application to apply for compensation for personal injury cases, and that's the lowest of all of them. And that would cover all these cases which would automatically be put into the small claims track. What it doesn't cover, the sort of injuries which are not covered by this scheme, is where the whiplash injury is connected to another injury which is not a soft tissue injury, as you described earlier. So, for example, if in the accident the person suffered a head injury, for example, or damage to shoulder, then that would not be covered by this scheme, and it may or may not be assigned to the small claims track.
And another consequence of a claim worth under £5,000, which is going to be most whiplash injuries lasting less than 24 months being assigned to the small claims scheme, is I assume that legal costs will no longer be recoverable. What's the impact of that?
Well, that's right. The idea of the scheme is to try to cut out the lawyers, as you would imagine. There's a portal. You can apply online and you can apply for a medical report, and then you go through the scheme. So strictly speaking, it should be a less expensive scheme.
Who, in your opinion, are going to be the winners and who are going to be the losers from this new scheme?
Well, first of all, let's deal with those who've suffered a whiplash injury. If the reaction of those who represent claimants is anything to go by, then the claimants are not going to be the winners. But then, of course, that includes the lawyers. There are a number of helpful points. The first of all, of course, is that the tariff provides certainty for those bringing claims because they know what they'll get, and it reduces the potential for legal argument and therefore protracted claims. Secondly, as I've said, the process is designed so that you can bring your own claim with an online portal, therefore designed to cut out the lawyers. And thirdly, this is interesting, the Act which brought it into force prohibits those representing parties, so lawyers, claims handlers and insurers, from settling or even offering to settle claims unless medical evidence has been obtained about the nature of the injuries. And indeed, if those professionals do so, they will be in breach of their professional code and could mean that they end up in front of their own regulator.
Thank you very much. That was James Counsell QC, a barrister from Outer Temple Chambers.